In this video, I'm going to share with you 5 tips for winning your restraining order hearing. And this applies whether you are defending against someone, requesting a restraining order against you, or whether you're trying to get a restraining order against someone else. My name is Veronica. I am a criminal defense attorney and restraining order attorney here in Los Angeles, and I help people put their cases behind them so that they can enjoy their lives, their freedom, and their family. So this video, again, it's going to be 5 tips that you can use to try to win your restraining order hearing, give you that best possible shot. Now, a lot of people cannot necessarily afford an attorney for a restraining order hearing, particularly because these are usually on an emergency basis. So for criminal defense, for those cases, in general, we can give a little bit more of a payment plan, but myself and a lot of other attorneys are not going to be as willing to do that when you need somebody to show up in court for you and win this thing for you next week. And so I end up talking to people all of the time who cannot necessarily afford to hire an attorney right now, but they have this restraining order hearing. Maybe their ex filed one against them and now they haven't been able to see their kids, and they are desperate to win this thing, and it's going to be a big deal if they don't. Or maybe maybe it's filed not even by their ex or very, very recent ex who filed against them, and now they can't even go back home. They're living in their car. They need to win this and they need help, but obviously they can't necessarily hire someone. Also, I have the pleasure of frequently, so I will get hired for these cases sometimes, but the other side doesn't have an attorney. And, I'm sort of laughing about this, because most of the time, I usually believe my clients in these cases. And when the other side is doing something that I think is really wrong, like filing a restraining order, lying in a temporary restraining order so that for 3 weeks until the formal hearing, my client won't be able to see their kids, little kids, and the little kids won't be able to see their parent, my client. I think that that's really wrong, and I absolutely love and cherish demolishing them when they show up without an attorney on the day of the hearing. And strategically, I generally don't inform them that I've been retained ahead of time. I don't want them to get ideas about hiring counsel. I want it to be, we're going to freaking go that day. You thought you were going to bully my client? Well, now I'm here, and it's not going to go the way that you thought. Anyway, but I watch them freaking flounder. And I also end up watching restraining order hearings from 2 litigants who are, neither one has an attorney, and I'll see some of them floundering where I'm like, oh, you, but I can't. I'm in the courtroom there, so just watching and waiting so I can help my own client. So let's go through these 5 things that you should know. So number 1 is do not interrupt. Do not interrupt the other side. Do not interrupt the judge. Do not interrupt, okay? And I mean this as an absolute rule. If the judge starts talking when you're talking, zip it. No more talking, please. Let the judge interrupt you. Do not interrupt the judge. I would also even go so far as to say let the other party interrupt you. If the other party is being inappropriate and interrupting you, let them, because the judge will see that they are unreasonable and they are a bully. Nobody in the courtroom, like any of the professional lawyers, clerk, judge, likes interrupting. There is a court reporter there, or in some courtrooms now in Los Angeles, they are just using like a recorder, but you can't, it messes up the transcript, and all court proceedings either will be transcribed or can be transcribed. So people can't talk over each other. So everyone who knows what's going on in the courtroom is like, just like really cringing when someone interrupts. Don't be that person, and let the other side be that person if they want to. Like, even more delicious if they interrupt the judge, which is going to piss the judge off. I have to add, I have a little list here, but I just have one more that I want to make sure I add that's a little bonus. 1 second. All right, that will be a little bonus. Number 2 is be organized. Have your documents ready Have at least 2 copies of each document. And I recommend putting the document in a binder. Let me see, I think I actually have one here that I can show without showing the client's name. Okay, ideally you have like a binder like this, right? Where you can easily just flip to it and get to any document that you're going to want to show the court. And don't think, some people will think, my clients will think, that you want to do like a kitchen sink approach. You want to give them, the judge, as many documents as you can gather about anything that's marginally related. No. The judge will be annoyed by that. The judge, many times, will have like 25 of these hearings on calendar. Find the documents that are actually relevant. Read the documents that the other side has written if they wrote something, or even look at your own if you filed something. Look at the documents that actually support that and use those documents and have them ready. Have them ready to go, have it nice and beautiful, so when the other side has, crumpled papers, is trying to show things on their phone, you are ready. Number 3. Bring a computer with you. Bring a laptop with you. If you have to do an iPad, I guess do it. But if you have a laptop or can borrow one, bring that laptop with you. And when you hear the other side testify, type up some questions as you go if you have any additional questions. You're not going to remember them. It's a high stress situation. Are you going to try to write them down? I don't know about you, but I am a much faster typer than I am like at handwriting things. And, the first few trials that I had as a trial attorney, I thought, I shouldn't be like using my computer to write things down. I want to look like the lawyers on TV that only have paper, and I don't have, this laptop in front of me that's kind of separating me from the judge. And I would have all of my questions for the witnesses printed out, but then I was trying to write on there, like, I have it organized by subject, and I'm trying to write in there some additional question based on what was just testified to. I think it's best, like, that's okay if you have no other option, but I think it's best to use a laptop. The first time that I decided to use a laptop was I got a trial at the very last minute, and I was kind of scrambling at like using every minute that I wasn't sleeping to work on this case, and so I just brought my laptop with me just kind of out of necessity. And at the end of the case, which I won, by the way, the judge complimented me saying, "Ms. Parton, you were so organized and so prepared." And I was like, I feel like I was kind of scrambling there. But the reason I realized that I always organize my questions by subject, which I think probably every attorney does, and is what you should do, but don't worry too much about that if you have a lot to worry about if you're trying to do this on your own. But I organized by subject, and then I would just add in the questions. It was super easy for me. They're bullet points. I would just add them in as I went. So that, I really think that is kind of like a magic bullet. I haven't seen that many attorneys doing that, but when I do that, it kind of frees me up to, first of all, I know I won't forget anything. I am very fast at typing, especially compared to writing, so I will get all of my questions in there. And it frees me up during cross-examination instead of trying to think of like, oh shoot, what other question did I want to ask? Like, trying to peer at like my own writing, which, if it's a lot of testimony, you might be like trying to peer at your own writing and you're writing in the margins and it's crazy and you're like, what does that say? This is much better. It frees me up to just work on my delivery of my cross-examination, which again isn't something that you should necessarily worry about, but it makes sure that I have everything there. It's more relaxing. It's much better. So hot tip there that you don't need to be a lawyer to know. Number 4, this one should be obvious, but you have to keep your emotions in check. You have to. You're going to get pissed off during this hearing. You're going to hear lies about you, and you're going to want to do maybe even what I just saw a self-represented litigant do against, or try to do against me and my client, which is objection. She's lying. That's not a valid objection. And don't get angry when you're getting cross-examined by the other side. If it's the two of you, like you guys just got divorced or something, you have kids, you still have to deal with each other, and you two are asking each other questions, do not let this turn into a marital dispute. The other side might get all fired up. That's fine. That's actually good. Let them do that. They've lost their cool. They look like a jerk in front of the judge. You stay calm and collected, because a lot of this is going to be about credibility. Unless there's video of one party like abusing or harassing the other, something very clear, it's about credibility. So if you keep it calm, if you keep it credible, that is going to go a very long way to the judge deciding in your favor. Number 5 is learn some basic objections. So one of the easiest ways to bulldoze a self-represented litigant is for me to object based on foundation. If you don't know what that is, look it up. This is not a crash course in evidence that I'm giving you right here, but it's basically like if someone's asking a question of another party, or if they're testifying about something that they say they know, you have to establish how they know, right? So you can't just say, and what color was her dress, what color was Veronica's dress that day? You couldn't ask that question without establishing first that the person saw me that day and that I was wearing a dress. You can't just assume all these facts and like snowball them into this, not snowball, but roll them up into this one question that contains all these assumptions and that assumes that the other person even has knowledge of any of this. So that's a big one. Hearsay is a big one. When people try to say any out-of-court statement that is offered for the truth of the matter asserted, unless there are a bunch of exceptions, is hearsay. So someone who's trying to bring in police reports, this was one that somebody just tried to bring in, that I objected to, and it was thrown out for hearsay. Try to learn some basic objections, and if you hear the other side, or you see that they have a document that's something that was said out of court, and they're using this to show that this is true, just object. Just say objection, hearsay. And if it's not hearsay, don't do it after everything that they say. You'll annoy the judge. But unless the judge sustains your first objection and they keep trying, then keep objecting with the same grounds, and the judge will probably get annoyed and tell them to move on. But object based on hearsay. If the judge doesn't agree with you, then the judge will overrule your motion, but otherwise you might shut down a lot of what the other side was planning to say, leaving them completely flustered and unable to present their case. All right, and now the bonus that I thought of and made you wait while I typed my note on is listen to the judge's questions and statements from the judge and try to figure out what he or she is thinking or what path they are going down, and go on that same path as much as you can. I even will look at the judge's face during a hearing sometimes when the other side is presenting something, because judges have tells sometimes. I mean, I can see the judge kind of like squinting or looking impatient, looking annoyed, sometimes looking back at me because they want me to object because they're tired of hearing whatever testimony it is. So try to look at the judge, see what they're thinking, listen to what the judge says. And again, if the judge tries to cut you off, you are cut off. Listen to why they're cutting you off. If the judge asks you a question, listen to the question and answer the question. Don't go off and say a bunch of other stuff. Don't ignore the question and talk about something else you want to talk about. The judge is asking that question for a reason. Anyway, I hope that you found this video helpful. If you do have a restraining order, if you are looking to hire an attorney in Los Angeles or the surrounding counties, Southern California, please feel free to book a call with me. You can call my number right down below, or you can also click on the link to book a consultation there.